My course is essentially about personal property law. We are going to look at personal property law and the law of secure transactions first from a comparative point of view. The law of personal property remains a little studied, in particular in common law countries. The main reason for that seems to be that traditionally most wealth was stored in real property, in land. For large parts of our history, land and real property was the main source of value, was the main source of power as well. But with the Industrial Revolution, this has changed. First, with the development of consumer societies, the number of goods, the number of chattels, of tangible movable property around has increased massively. So in the course of this development, an understanding of the law of personal property became more and more important. And since the beginning of the 20th century, the law on intangible property, on debt receivables, on investment securities has become more and more significant. Today, large amounts of wealth are stored in intangible movable property, in particular in debt receivables and in investment securities. At the same time, the legal concepts that are used in developed economies, in Europe, in the United States, remain underdeveloped. Often the concepts that have been used in the context of land are to a greater or lesser extent still used in order to conceptualize the legal concepts in order to analyze intangible property as well. My course tries to provide a clear theoretical framework and a toolbox that allows students to effectively deal with these concepts and to understand these concepts in a transnational context. In this particular area of law, so in the law of personal property and secure transactions, the difference between common law and civil law matters. And these differences are actually significant. These differences matter because proprietary interests, personal property law, is not, in general, is not subject to party autonomy. So the parties are not free to negotiate, are not free to agree on the law that applies to the proprietary interests within their relationship. So it matters where the asset is situated, and if the asset crosses borders from, say, a civil law country to a common law country, then the applicable proprietary regime changes. And contrary to contract, where in particular in Europe we've seen a significant convergence over the years in terms of contract law, the differences in personal property law remain very significant. In particular, when we look at civil law, the law on personal property is derived from Roman law. Roman law has a unitary concept of ownership. Ownership as the most comprehensive right that one can have in an object, in an asset. And from this comprehensive ownership right, limited proprietary interests can be split off. Ownership can be conceptualized or can be imagined like an onion, where you can peel off limited proprietary interests. They are limited in the sense that they are less than ownership, that they give the holder rights only in one particular aspect or in a number of particular aspects, but are less comprehensive than ownership. But they are still proprietary in nature because these rights are good against the world. They are also enforceable against the owner itself. And when these limited proprietary interests come to an end, they automatically revert back into ownership, so that the ownership, the onion, is whole again. In addition to that, other important concepts, basic concepts in civil law are possession and holdership. Possession is actually not a right, it's a fact. It's a physical and psychological fact. It requires the control, the actual physical control of an asset combined with an intent to exercise this control as the owner. It is not a right, it's a fact, and but as a fact it is important in particular for the acquisition of ownership, for the acquisition of limited proprietary interests as well. And then we have holdership that is also based on physical control of an asset, but the intent is different. The intent of an holder is to exercise this control with an intent to hold the asset for somebody else, usually for the owner, but subject to one's own right to use. So in civil law we have these three categories: ownership, possession and holdership. Whereas in common law, first we have the distinction between law and equity. Historically, common law and equity developed as two different branches of the legal system that interacted at various levels. But in the realm of personal property law, we have at law only two proprietary interests that can be created: ownership and possession. Ownership is defined as the residue of rights that remain after specific interests have been granted. So ownership can be defined as an absolute interest, whereas possession is a right that gives a relative interest. This is then combined with the doctrine of relativity of title. So the owner would hold, the owner in possession, in physical control of an asset, would hold an absolute interest and an indefeasible title. If the owner then grants a bailment, by way of bailment, possession to a bailee, then this bailee would be in possession, would hold a relative interest, but also with an indefeasible title, whereas the owner's title becomes relative because it is subordinated to the possessor's title. Generally speaking, in common law, possession is the stronger right because protection under the law of tort is based on possession rather than ownership, whereas in civil law, protection is based on the actual right by way of the old Roman action of the re vindicatio. Even people with a civil law background have heard about the trust. They usually come across trust structures in the context of the law of succession, foundations, charities, where trusts are very frequently used also for tax optimization purposes. But trusts also have a very significant scope of application in commercial settings. Trusts are very useful for a number of reasons. One reason is that they come with a very strict fiduciary duty structure. This fiduciary duty structure is very similar to the fiduciary duties that a director owes to its company. These fiduciary duties, they provide a blueprint. They cannot be easily opted out from if they are appropriate in a particular setting. And these fiduciary duties are also owed to the beneficiaries directly. That provides greater protection for the beneficiaries under trust as compared to, say, shareholders in a company. Another important feature of the trust is that the trust property, the trust fund, is insulated within the property of the trustee. The trust fund is not available to the trustee's personal creditors. So what the trust achieves is asset petitioning similar to a corporate entity, however, without the formalities and the registration requirements that come with a corporate structure. And generally speaking, one great advantage of the trust is its flexibility. In particular, the beneficial interests, they can be subdivided, they can be parceled out, they can be sold on separately, they can be used as collateral. So this flexibility makes the trust very useful in commercial settings as well. In particular, trusts occur in collective security agreements. They occur in the context of securitization. And civil law countries traditionally have difficulties in accommodating the trust within their structures. Some civil law countries, notably France, reformed their law in order to provide something similar. In France, since 2007, there's a concept called fiducie, which tries to mimic trust structures, but in a much more restrictive and less flexible way. Debt receivables have essentially a dual nature. They have an internal aspect that is usually governed by contract, the contract between debtor and creditor, but they also have an external aspect. And the external aspect means that they constitute an asset that can be transferred, that can be sold, that can be used as collateral in order to secure another debt. These days, a lot of wealth is stored in debt receivables. And in particular, the transfer of debt receivables or the use of debt receivables as collateral has the purpose to obtain liquid funds very quickly, liquid funds on the basis of a debt that will become due at some point in the future only. Factoring as a line of business is very important, and it's very important for businesses in order to obtain liquid funds for their day-to-day business activity. The problem with the law on debt receivables is that it remains understudied, it remains under-conceptualized. The problem is that the traditional proprietary concepts that were developed in terms of land and developed in terms of chattels do not easily fit debt receivables. So in many legal systems, the law requires, for instance, a notification of the third-party debtor in order to make an assignment of debt receivables binding on third parties. This is obviously not suitable for practice if you think of bulk assignments and the like. Another problem has to do with the applicable law. For the proprietary aspects of assignments of debt receivables, the lex situs rule applies. Now, debt receivables are intangible assets, so they do not have a situs in the traditional sense. And therefore, legal doctrine and academia has struggled with defining, determining the appropriate conflicts rule for the law of assignments. Investment securities are negotiable instruments that can be used by governments or corporate entities in order to raise finance on capital markets. The most traditional forms are bonds or shares, and then we have hybrid instruments that combine to a greater or lesser extent the features of bonds and shares, of debt and equity securities. These days, investment securities are held through long chains of intermediaries. So we have to dispose of the notion that any particular shareholder has a direct interest in the company that they are investing in. Rather, they hold their shares through an account with their bank through an account with a bank further up in the chain, and then finally through a central securities depository. This raises the question as to how to classify the interest that the end investor actually holds. And here again, common law and civil law differ. In common law systems, in particular in England, this is usually classified as an equitable proprietary interest, a beneficial interest under a chain of trusts, whereas in civil law countries, the legislator had to step in and had to provide a specific form of co-ownership. One interesting academic debate concerns the efficiency of a law on secure transactions, or rather the question whether having a law on secure transactions is actually efficient. The traditional law and economics answer is that by providing security and by obtaining security, a creditor can actually reduce the costs that he spends on monitoring the debtor and also monitoring the other creditors. So by having secured credit, monitoring costs are reduced, therefore the costs of credit are reduced, more credit is available in society, and therefore credit becomes more widely available, resulting in more growth in a society. Whether this is in fact true is a different matter, because some people say secured credit is basically a zero-sum game. The costs that are saved on secured credit has to be added to the costs on unsecured credit, because for unsecured creditor now the whole transaction becomes more risky, and therefore the costs would be increased for these unsecured creditors. Be that as it may, today we see the widespread use of secured credit. This is at least an indication that secured credit is efficient. In terms of the structure of a law on secured credit, we have to keep in mind that we want to have a regime that is cheap. This means that the formalities upon creation of a security interest should be minimal, although we also have to guarantee that there is adequate publicity in order to protect third party. Throughout the lifetime of the security interest, we have to make sure that the debtor can remain in control of the asset in order to secure, in order to generate actually the cash flow that is needed in order to repay the debt. And when it comes to enforcement, we want to have a fast and efficient enforcement procedure that ensures that a maximum value of the asset is being realized. Traditionally, we can distinguish between ownership-based funding and security interests proper. Security interests proper are traditionally used in order to secure loan credit. Security interests proper are characterized by more or less strict requirements, strict formalities upon creation, more or less strict formalities upon enforcement, and a mandatory risk and reward structure. By contrast, ownership-based funding is traditionally being used in order to secure a sales credit. Ownership-based funding, as the name suggests, is based on ownership. The creditor remains or becomes the owner of the underlying collateral. This means that there are hardly any formalities upon creation of the security. When it comes to enforcement, the creditor can simply enforce as an owner his ownership right, which renders ownership-based funding usually less complex, cheaper, and from the point of view of the creditor, more desirable. As a consequence, what we increasingly see is that ownership-based funding techniques are used to secure traditional, would traditionally be characterized as loan credit. And this in turn raises the issue of recharacterization. In the area of personal property law and secure transactions, there are a number of conventions in force, in particular on international factoring. These conventions have had little impact in practice. This is different for the Cape Town Convention on International Interest in Mobile Equipment. This convention has had a significant importance in practice. It provides for an international security interest in railway rolling stock, aircraft, and satellites. Only the convention in respect to aircraft is in force at the moment, but it provides an international interest that is, to some extent at least, detached from national legal systems.